Good evening and welcome to Cheltenham Borough Council Licensing Subcommittee Miscellaneous, being held on Wednesday the 15th of November 2025. My name is Councillor Simon Wheeler and I am Chair of this committee. This meeting is being streamed live to Cheltenham Borough Council's YouTube channel, and the recording of the meeting will be held for 4 years. If there are any breaks in transmission to the YouTube stream, the meeting will be adjourned for a short period until any issues are resolved. If you are here to make representation to the meeting, you are consenting to the use of sound and video recordings for broadcasting and training purposes. Please be aware that CCTV and audio recording is being operated in the public gallery. The recordings will be held by the council for 5 months. Please note also that a fire alarm test is not expected, so if the alarm does sound, you should immediately make your way to the nearest exit. There. Right. Agenda 1. I have received apologies from Councillor Willingham, but I thought he was here. Yes. Right. So yes, I've received apologies from Councillor Willingham. Please can members now introduce themselves?
I'll start if you like. I'm
yes.
Alan Pemberton, Councillor for Battledown.
I'm Steve Steinhardt, Councillor for Benhall, the Readings and Fiddler's Green.
Councillor Julie Sankey of Hatherley.
Councillor Angie Boyce, Charlton King.
Thank you very much. Right, declarations of interest. Have any members got any declarations of interest?
It was just to say a few of us went to visit the erotic cats earlier in the year.
Sorry, can you repeat that?
Sorry, yes. So 3 of us councillors, or 3, went to visit erotic cats earlier in the year. We went out with licensing.
Okay,
visit
thank
the premises.
you. Councillor Boyce?
Yeah, same. Visited the premises when it's operational and also non-operational as well.
Me too. So I've also visited the premises.
Okay, we'll take that all as read. Thank you.
I've been there as well.
Agenda item 3, application for renewal of a sexual entertainment licence. Because this is a regulatory item, members must be present and have heard of the proceedings in their entirety to vote on this item. We will ensure that the applicant and the representatives, on the applicant's representatives, if they have one, are present in the meeting. I will ask the licensing officer to introduce the report. Members will get the opportunity to ask the licensing officer questions. Then the applicant or their representative will get an opportunity to ask the licensing officer a question. Today, the objectors aren't present at the meeting. Their representations will be read by a Democratic Services officer. The applicant or their representative will be given the opportunity to present their application or make their case. Members can ask the applicant questions. The applicant or they will be given the opportunity to give their final right of reply. Members will then retire to make their decision. When members return, they will give their decision and the results of the vote. So I would like to invite the Licensing and Public Protections Manager to introduce the report, please.
Thank you, Chair. Thank you. This is an application for the renewal of the sexual entertainment venue licence in respect of the Erotic Cats, 30 Cambray Place, Cheltenham. The applicant is Red Apple Associates Limited. The Director, Mr Stephen Burrows, is present today and he's represented by his solicitor, Imogen Moss from Pobston Allen Solicitors. The renewal application is to authorise the premises to provide relevant entertainment on the dates and times as outlined in 1.3 of your report. In addition, the applicants have also applied to vary two of the standard licence and conditions, number 6 and 25, and the proposed wording is outlined in section 1.4 of your report. In addition to this, the special condition to be varied to read as follows. Banners promoting erotic cats on the exterior of the building must be removed no later than 1 hour after closing and shall not be erected earlier than 1 hour before opening each evening. A copy of the application form along with supporting documents are attached to Appendix A. A copy of the premises existing SEV licence is attached to Appendix B. On the 1st of October 2014, Council approved the adoption of the amended provision of Schedule 3 of the Local Government Miscellaneous Provisions Act 1982 to take effect in the Borough on the 1st of December 2010. Since the adoption, any premises that want to offer relevant entertainment on a frequent basis can only do so by obtaining a SEV licence. Relevant entertainment is defined as any live performance or any live display of nudity which is of such a nature that, ignoring financial gain, it must be reasonably be assumed to be provided solely or principally for the purpose of sexually stimulating any member of the audience, whether by verbal or other means. Under the Act, premises can provide relevant entertainment on an infrequent basis without the need for a SEV licence. The application has been advertised in line with the statutory advertising requirements. In relation to this application, the licensing authority received 73 representations. These were made up of 2 objections and 71 representations in support of the application from residents and others during the statutory consultation period. Copies of these are outlined in Appendix C of your report. There were no comments or objections made by Gloucestershire Police. In determining the application, members must have due regard to any observations made by the Chief Officer of the Police and any other comments made by anyone else. Members are to note in particular that any objection must relate to both or either of the mandatory or discretionary grounds for refusal set out in my report. Objections made on moral grounds or values that are not relevant to either the mandatory or discretionary grounds for refusal and should therefore not be considered relevant. This application must be determined on its individual merits, taking into account the matters outlined in the report, the relevant statutory provisions, the authority's adopted policy, the relevant guidance issued by the Home Office, and any objections or comments made by the Chief Officer of Police or other persons. In particular, the committee must bear in mind that its grounds for refusal of the licence application is restricted to those specified under the statutory mandatory and discretionary grounds. For reference, they are outlined at paragraphs 4.4 and 4.5 respectively. As such, the relevance of representations made in relation to this application must therefore also relate to those mandatory and discretionary grounds for refusal. The committee is also reminded that the authority does not take any moral stand in relation to the operation of sex establishments such as sexual entertainment venues, because the authority recognises that Parliament has made it lawful to operate a sex establishment and that such businesses are a legitimate part of the retail and leisure industries. It is the authority's role as the licensing authority to administer the licensing regime in accordance with the statutory provisions. As the application is seeking to vary the standard SEV licence and conditions in our policy, the committee must not arbitrarily deviate from its own adopted licensing policy. Where the committee consider there to be exceptional circumstances that may justify a deviation from its licensing policy, this must be thoroughly reasoned and recorded. As mentioned in my report, the venue sits inside the council's designated permitted area and has been granted a licence previously. The authority must recognise, however, that the designated permitted area offers a more varied situation inasmuch as it has a much wider mix on offer, particularly in the nighttime economy, and it may therefore be appropriate to consider applications for SEVs in that area. The authority has therefore resolved that it will not set a limit on the number of permitted SEVs in the designated permitted area, providing those premises are not near properties with sensitive uses or in sensitive locations. In considering if the grant, renewal or variation of the licence would be inappropriate, having regard to the character of the relevant locality or to the use to which any premises in the vicinity are put, the authority shall consider, amongst other things, whether the grant of the application would be appropriate, having regard to the fact that the premises are sited in a residential area, whether the premises are sited near shops used by or directed at families or children, or on frontages frequently passed by the same, whether the premises are sited near properties which are sensitive for religious and/or whether the premises are sited near premises or areas which are sensitive because they are frequented by children, young persons or families. The public sector equality duty places a statutory duty on the council in the exercise of its functions to have regard to the need to eliminate discrimination, harassment, victimisation and any other conduct that is prohibited by or under this Act, advance equality of opportunity between persons who share a relevant protected characteristic and persons who do not share it, foster good relations between persons who share a relevant protected characteristic and persons who do not share it. Protected characteristics are age, disability, gender reassignment, pregnancy and maternity, race, religion or belief, sex and sexual orientation. The licensing and regulation of SEVs does fall within the authority's public sector equality duty and therefore the authority must have regard to the matters listed above, for example, setting policy and issuing licences. In addition to my report and supporting appendices, the applicant's solicitors have submitted a disclosure, including an equality impact assessment, which has been published ahead of today's meeting. Having considered all the relevant matters, the committee must decide whether to A, grant the application as applied for, B, grant the application subject to any additional terms, conditions and/or restrictions that are either specific to the licence or standard conditions, or C, refuse the application. Thank you, Chair.
Thank you. Are there any questions from members? Councillor Boyes.
Thank you, Chair. Just two questions. Are the rough dates and timings the same as what we've previously licensed? And have you ever received any complaints about the applicant?
Thank you, Chair. The times and we haven't received any complaints regarding the premises.
Anyone else? No? Do the supporters have any questions of the officer? No, thank you. I'd like to ask Democratic Service officers to read the representations of the objectors, please.
These are the two statements that we've been asked to share from the objectors that can't attend. So the first one reads, Gloucestershire Women's Liberation Collective would like to thank the Licensing Committee for the opportunity to contribute to this evening's meetings. Impact on the lives of women and girls. Strip and lap dancing clubs where women are sexually objectified and the idea that men are entitled to access women's body is reinforced. Contribute to harmful sexist and misogynistic attitudes that underpin the endemic abuse, harassment and violence against women and girls in society. Recent research carried out by the National Police Chiefs Council has described the scale of men's violence against women and girls as an epidemic and a national emergency. Much research, including that carried out by the United Nations and our own government, show the link between harmful attitudes and sexual violence. The most recent Cheltenham Borough Council Violence Against Women and Girls Safety Survey highlighted that only 5% of respondents felt very safe, with around 68% of respondents feeling not very safe in Cheltenham during race week. We know from our own research that women change what they usually do in Cheltenham during race week, with many avoiding the town centre. Women have told us of routine harassment from drunk men, their experiences of fear and powerlessness, and feeling like an object just for men's amusement. Specific complaints included turning the pubs into strip clubs, again only reinforces objectifying women, and the SEVs make the atmosphere really unpleasant and unsafe for women. Public sector equality duty. We remind the committee of its statutory duties under the public sector equality duty to have due regard to the need of A, eliminate discrimination, harassment, victimisation and any other conduct that is prohibited by or under the Equality Act. B, advance equality of opportunity between persons who share a relevant protective characteristic and persons who do not share it. C, foster good relations between persons who share a relevant protective characteristic and persons who do not share it. We remain concerned that the sex equality concerns that we have raised in our submissions are not being adequately considered, and therefore the committee's obligations under the public sector equality duty are not being fully discharged. Frequency exemption. We are told that the committee's hands are tied in respect of the grant of SEV licences due to the existence of sexual entertainment frequency exemption. Legislation allows for these provisions to be repealed, and we hope that the committee will continue to use whatever influence it has to lobby Parliament for such a change. Gloss Women has written to Jess Phillips, MP, Minister for Safeguarding and Violence Against Women and Girls, to request that the sexual entertainment venue frequency exemption be reviewed as a matter of urgency. In their response to us, the Home Office said that they are considering, as part of the government's VAWG strategy, how they can address the various drivers of VAWG, including the objectification of women and girls. Variations to SEV policy standard conditions. If SEV licences continue to be granted, then they must be licensed on the strictest terms possible. Since we have engaged in the SEV licensing process, we have seen watering down of standards conditions in areas such as advertising, soliciting and operating hours, with scant evidence to justify such changes. We note such variations have again been submitted as part of this application. A proposed variation to standard condition 25 allows for bodily contact between performers. We are concerned that such a variation represents a blurring of boundaries, which could put women performing in the venue at increased risk of harassment and/or assault. A culture where sexual violence is unacceptable cannot be created where the sexual objectification and dehumanisation of women and girls is reinforced by the way of SEVs. We urge the committee to listen to the voices of women and girls and show a commitment to their public sector equality duty in deciding the outcome of this application. And that was from the Gloucestershire Women's Liberation Collective, who agreed to be, wished to be named in the proceedings. Then this is a statement from, I believe, number 49 in the pack. Objector number 49. I understand that the frequency exemption means the council will feel it has no choice but to issue this licence, but I ask them to avoid watering down their own licence conditions. These conditions, including those relating to advertising, did not come out of thin air. They are based on the council's own 2020 Community Impact Statement, which describes the inherent risk for performers who work in sexual entertainment venues. It also states the council is aware that females in particular feel disadvantaged by the sexual entertainment and licensing of SEVs. This is manifested in both a general sense of feeling objectified and more specifically through feeling intimidated and unwelcome in the vicinity of the licensed SEVs. As a result of these concerns, the impact statement says a number of policy conditions have been tightened up, including those relating to promotional staff and promotional activity in the vicinity of licensed SEVs. Given this context, it is concerning to see the applicant has again requested a variation to their licence conditions, which among other things mean they can hand out bus flyers outside the club and use a marked vehicle to transport customers. Some might say that the Dream Boys is advertised freely and it is unfair to treat erotic acts differently. I suggest they remember that there is an epidemic of male violence against women and girls, not an epidemic of female violence against men and boys. Strip clubs normalise the objectification and dehumanisation of women and girls. The council is right to issue a policy that limits the ways these clubs are advertised. Some might say that far worse is available online. This is true, but again, not an argument for allowing strip clubs to, in effect, be advertised freely. As well as enforcing their licence conditions, I ask the council continue to lobby the Home Office to remove the frequency exemption. According to the not buying it guidance, strip clubs and the law, this is a relatively easy process which does not require new legislation. As Cheltenham MP Max Wilkinson says, the exemption in the law that allows pop-up sexual entertainment makes a nonsense of licensing regulations and creates added risk for women and girls. Thanks.
Thank you. I'd like to ask the supporter then to address the committee, please.
Hello. I'd like to say thank you for the opportunity to speak at this hearing tonight. It is something that I feel very passionately about. I've worked with the Rotocats for well over a decade now as a performer and as a house mother, which is my current position. My role includes a range of responsibilities, but the safety of performers is a big part of that. Rotocats is the only event or club I have encountered that takes performer, customer and staff safety as seriously as they do, and that is one of the main reasons I continue to be involved in the operation. I work alongside an excellent security team and feel incredibly supported during and after my shift. It's very rare to find clubs or events that make sure every performer and staff member gets home okay. In fact, that's pretty unheard of in the industry these days. The courtesy bus plays a vital role in doing that. Whilst I understand the reasons behind some of the objections this licence receives every year, I do feel that many of them fail to recognise the facts here. Rotocats is a well-run, safe, organised, conscientious, legal business. I would not continue to be involved in the event if I didn't fully agree with the way that things are being conducted. As a woman who knows the industry inside and out, I can categorically say that not granting this licence would leave a gap in the market to be filled by another provider who is highly likely to exploit performers and customers for quick cash whilst taking no accountability for the security and safety of either. During my time in the industry, I've encountered many operations and club owners and event organisers that do just that on the regular. To grant this licence means structured, regulated and safe experiences for everyone involved. Thank you.
Thank you. Any questions from members of the supporter? So I would like to invite the applicant to address the committee.
Thank you very much. Just a couple of bits of housekeeping before I talk about the application. I just wanted to clarify that the appendices refer to revised plans. I think it's just because they were revised a few years back. They're exactly the same plans that were granted at the previous renewal. And then the special condition, there's no variation to that wording. We're just simply requesting that be added back on should you be minded to grant. It's just because it's not part of your standard conditions, so we've asked that that condition go back on. It's not any different to that which we agreed last year at the last renewal. So I'm not going to go back over the actual application itself because the officer's report has very succinctly done that for you, and I'm just conscious of everybody's time. So I'm going to turn first to the mandatory grounds. None of the mandatory grounds for refusal apply here, so we have to look at discretionary grounds. A to C don't bite, so we have to look at the character of the relevant locality, the use to which premises in the vicinity are put, and the layout, character and condition of the actual premises themselves. No issues have been raised in respect of the objections in respect of the layout, character and condition of the premises. When we're looking at the locality, the premises sits within the council's DPA. It's operated as an SEV since 2021. And again, like the officer's report said, the DPA is recognised as being an area of a real mix of the nighttime economy and somewhere where SEVs can be considered. The venue has a history of compliance in respect of signage. It operates discreetly as an SEV on specific hours on a limited number of days per year with minimal impact on the locality or other premises in the area. That's been shown year on year whenever it trades, and again we're not asking for anything different at this renewal that was renewed last year. Nothing material has changed in the locality either since the initial grant actually of the application. Looking at the application generally then, Well, the premises have operated as an SEV since 2021, and the applicant themselves has operated SEVs since 2010 in Cheltenham, both under what is the lawful frequency exemption and as a fully licensed operator. The objections talk a bit about the varied conditions. So again, I just wanted to briefly go over that. We've requested the same variation to the conditions as was granted last year in respect of the courtesy vehicle and flying for the courtesy vehicle, and also that has been varied, that wording has been varied since original grant, and it's operated under this condition without issue at all. All the advertising and promotional material, and it seems like a silly point, but it's a really important point, is it's related to the courtesy bus. It's not advertising the actual premises themselves. The courtesy bus is a really important part of the operation. It helps to transport performers both before and after the premises open and close. At no point are customers and performers ever in that vehicle at the same time. It also helps, you know, huge amounts of people, as you well know, during race week, and it means that people can get from A to B in a safe fashion. There's never been any issues with that, and you will have seen the flyers and what the actual bus looks like in the appendices in the agenda. So just to be clear, there's no change to what we're varying there. That's just how that's been since grant. The variation to condition 25 is an important one as well. As per last year, this is to clarify the wording of that condition so that both the operator and authorities can be clear on what the condition is actually seeking to achieve. Because when you look at the standard conditions in the policy, you can read that condition one of two ways. So we had quite a lot of consultation with licensing and the police. We know what the intent is behind that wording of that condition, and we don't want there to be any misinterpretation of that condition leading to a technical breach, i.e. a performer tapping another performer on the shoulder to get their attention, for example. So we came to this agreement between all parties to say, actually, this was the intent, this wording meets that requirement, and it adds that element of safety for performers as well, to be honest, because they want to be able to operate safely without being in fear of, you know, just brushing past somebody or touching somebody on the shoulder shouldn't mean that they're getting told off for, you know, breaching the licence conditions. And then the special condition again, that's as per last year's renewal, that's to be added in again. It works well and it helps the venue to maintain its discreet appearance and have minimal impact on the locality and other premises in the area. Essentially, the varied conditions, they're really minor in their effect and they're simply about the practicalities of the operation. You can appreciate that there's a lot of health, safety, performer safety, customer safety, all those kind of things going on, and having these conditions tweaked to the nature of the operation and what we know works well as experienced operators, it is only going to help maintain that performer and customer safety. There have been 2 representations against the application to renew and a significant number of representations in support. So I just want to talk a little bit about the couple of representations that have been received. So the representation on page 73, it talks about the watering down of the committee's, the council's own conditions. To me, that is a bit of a lack of understanding of the history and operation of the venue. The bus has been discussed at each hearing since the initial grant. And again, the operators confirmed and given, you know, an account of how important that is and a safety feature for performers, as has the objector who's in support of who's in support of the application, who, you know, knows about this and knows how crucial it is to the safe transportation of performers who wish to use that service. They don't need then to rely upon taxis, public transport and things like that. It also aids the safe transportation of customers. And again, like I've said before, and I want to reiterate, the flyers are only in relation to the bus service and may have been approved on an annual basis. And again, they talk about enforcing their own licence conditions, which the council, it does, it's rigorous about it. You know, we've heard from you at the declarations of interest. You go out, you visit, you inspect, you enforce, which you can only do properly with a licensed venue because you know who they are, what they're doing, when they're doing it. So, you know, you do go out, and the police also go out and do their inspections as well. There's briefings before race week or, you know, in November and March. There's briefings afterwards, what went well, what didn't. you wouldn't be able to have those conversations with a pop-up operation like you do with a licensed operator. Being a licensed venue, robust policies and procedures, you've seen those, you've had those, you know what they look like, you know that the that the operator, you know, that they do have those in place, they operate to them with diligence. They're proud of that as well, they're proud of their commitment to perform our own customer safety. The committee can only also work within the legislation as it stands. So, you know, giving consideration to the benefits of a licensed operation is a legitimate thing to consider. It also, there's a representation at page 53, and that's from the Gloucestershire Women's Liberation Collective, and that refers to the violence against women and girls research carried out by the National Police Chief Council. I went and I looked at that and I read it in depth, I read the summary and I read the whole document itself. I couldn't find a link in the report that was cited that had any direct correlation to SEVs. It just, there's a myriad of really complex reasons as to why, you know, it's depressing read, but ultimately there's lots and lots of really complicated reasons as to why this is happening. The research study that they refer to, the Safe and Equal Bristol report, that in itself was criticised by the Bristol Sex Workers Collective, and they said that a nil cap on SEVs would drive performers into unregulated underground environments without legal protections or safe workplaces. And ultimately, Bristol made their decision that at that point, you know, nil cap wouldn't work. The Plan International is also referred to by the objector and talks about women and girls not feeling safe. Unfortunately, and it is unfortunate, that's an issue that's experienced 365 days of the year in lots of different locations, be it rural, be it towns, be it cities, lots of different places, not just in the locality of SEVs or when SEVs are in operation. The reasons for girls and women not feeling safe, like I say, are complex and varied, and it's reductive to lay this at the door of an SEV which operates on a limited basis where there's no evidence offered of a direct and causal link. There's also reference made to the public sector equality duty, and I appreciate there is that obvious tension there between the grounds for abduction and what is a lawful activity. And there's also tensions between objectors regarding the perceived objectification of women and the free choice of performers to perform at their own will. It's not an easy position for councils to be in, I appreciate that. The IOL Journal of Licensing from July 2022 gives really good consideration to that, and you've probably, over time, you've all seen that, you probably all get that publication. And this particular article is authored by Jeremy Phillips, KC and Michael Feeney. And they state it's crucial to remember that the public sector equality duty does not require a specific outcome, and the duty is to have regard to the three equality objectives. So the applicant is doing all that they can to address those particular concerns and concerns that have been raised by objectors. They've drafted their own equality impact assessment, which you've been provided with. They participate in local safety schemes, including the steering committee for violence against women and girls in Cheltenham. And they've always worked in partnership with authorities in a transparent and collaborative fashion. The authority is also playing its part. You know, you've engaged with government yourself, and, you know, you've got the licensing policy review going on. So, you know, you are doing your part in respect of that public sector equality duty also. Lastly, the representation talks about concerns about women's safety, but it's important to note that there hasn't been any representation from the police. If there were any concerns about women's safety directly linked to this venue, they would have objected. And the police are the authority on crime and disorder, so due weight needs to be given to the fact that they haven't objected to this application. And I think as well, I'd just point out there's a significant number of representations that are in support, and a lot of them recognise the fact that having controls and having a licensed venue is fundamental safety for everybody, really. So, yeah, I mean, in summary, the venue's discreet. You've all been there, you've seen it in operation, you've seen it when it's not operating as an SEV because, you know, it only operates on very limited basis throughout the year. You've got an applicant here that's got an exemplary history of SEV operation at the premises, and a lot of the performers, they return year on year, which should give some comfort and indicate that it's a safe and reputable venue. Again, the survey that's referred to in one of the representations regarding women feeling unsafe in Cheltenham, that is disappointing. Anybody that would read that is disappointing. But the results need to be considered in regard to the context of Race Week. You've got nearly a whole city that comes into Cheltenham, a huge number of visitors over those number of days. So that has to be taken into consideration when you're looking at the context of those comments. Failure to grant a licensed SEV operation, it would have a negative impact on performer welfare and safety. And the activity applied for is lawful. And as we've spoken about, it is better, quite obviously, to have a licensed venue with robust policies and procedures, but have conditions. You have the ability to go and inspect, and you can't do that when you're relying on the frequency exemption. The application requested is no different to that which was applied for last year, and we have no evidence that's been offered by any of the objectors that any of the hours that have been applied for or any of the varied conditions that have been applied for would be problematic. There's been no real evidence supplied in respect of that, and you can see from when you visited yourself, and certainly we're not aware of any issues, certainly haven't been raised to us about the operation under those varied conditions and those hours. So with all that said, we would respectfully request that the committee consider to grant the application as applied for, and I'm happy to answer any questions.
Thank you very much. Are there any members' questions to the applicant? No, I think we've all been here before. So you have your final right of reply.
There's not too much for me to say on a right to reply, really, other than, like I say, you know, that it is disappointing when you read some of the documentations that are supplied, but, you know, at no point is any evidence linked directly to the SEVs. You've got Mr. Burrows here who, you know, he is open, transparent operator, works well with the authorities. He's definitely well involved with the community, with lots of different organisations, including, like I said, the steering committee for VORG. And I think, you know, you've seen from the renewal process, the grant process, everybody's seen how tight a ship that the applicant runs. And, you know, from hearing it from somebody who knows the business and understands the industry intrinsically, I think is really, really important. It's an important statement to take on board. So I've got really nothing else to add, as we haven't got any of the objectors here, other than to say, you know, this is a well-run operation. It's a well-understood operation as well. We always write to you. You know, Michelle, I wrote to you on another matter saying this is the hours we're going to, and these are the dates we're going to run, so everybody knows, and the police get to know about it as well. So everybody's aware ahead of time as to what's going on. And if there's ever any problems, you speak to Steve or myself. So yeah, in that regard, I've got really nothing else to add, I'm afraid. Thank you.
Thank you very much. Right, do members feel that there's a need for us to retire to discuss this, or can we discuss it in open? Councillor Boyes.
I think with due courtesy to the people who have actually turned up tonight, there's at least 5 people here who have come and they put together a huge amount of work, and also there are people watching online, and I do think that we've always carried out our deliberations in open session, and I think we should be doing the same tonight as well.
Yes, thank you. And that was where I was coming from, because my paperwork actually says that we'll retire. But I think in openness, I think it is reasonable to discuss it. So, does anyone want to start? Councillor Boyes.
Thank you, Chair. So we must recognise, I actually just want to say as well, thank you so much for the amount of information that you provided us. It was really thorough. I really appreciated that. We must recognise that Parliament has made it legal and lawful to operate a sex entertainment establishment, and that such businesses are the legitimate part of the retail and leisure industry. We have to regard the observations by the police. The police had no objections, and I think that's really important. There's no mandatory grounds for refusal, And regarding discretionary grounds, the applicant is suitable. There's been no complaints about him. We have licensed this venue for a number of years without complaints. And they clearly work within the community. They've got a huge amount of security there. I've been there myself. I've seen it. I have to declare that I've also seen places that work under the exemption, and it's very, very different. The authority has already resolved that it will not set a limit on the number of SUVs in the area. Regarding the character of the area, I'm satisfied it's within the nighttime economy area and it falls within the designated area. And that we have previously agreed that the location is appropriate. And the premises themselves are more than acceptable. Really happy to see the equality impact assessment that covered off on a huge amount of things there. So with regards to the public sector equality duty, I'm really very happy that we are having due regard to it. I think we've had due regard to it. We all looked at that statement and I really agree that everything is covered off there. Happy with that. Happy to see the reference to the European Convention on Human Rights, which celebrated its 75th anniversary yesterday. So be happy with the house rules, the amount of support there, the general management document. With regards to the objections, I have read them all, and whilst we cannot take into account in our decision making if they're moral objections, I do feel for the women who feel unsafe in Cheltenham and Raceweek, and I fully sympathise, but we can't pin that bad behaviour on one venue. And whilst everyone agrees with sexual entertainment, well, not everyone agrees with it, but it is lawful. The safety of the public, the customers and performers is our top priority. And for that reason, I would like to see the application granted with the attached conditions, and to not grant it would, I think, be unsafe for the population of Cheltenham. And yeah, more than happy to see this application granted again. Thanks.
Thank you. Yes, Councillor Stanhart.
Thank you. Yes, my colleague, Councillor Boyes, put it all very well and succinctly, and I totally agree with her. I had the opportunity, along with some of my colleagues, to visit the venue and one of the unlicensed venue, and the difference was phenomenal as far as the safety of the women goes in the licensed premises. So I do really support this on the basis of as presented. I have to say, in the objectors, there has been, as we noted, lobbying by this committee and the council for a change in the legislation on the frequency exemption to Jess Phillips, and we hope that that will be sorted out in the near future. Thank you.
Thank you. Councillor Pemberton.
I don't think I've got anything else to add, really. I think my colleagues have said everything that needs to be said, and I can't think of a reason to not licence.
Yes.
Thank you, Chair. Yeah, this is always an area that attracts a lot of attention, as we know. But actually, it feels like the objections have decreased this year, which I think is really telling. And I think people are understanding how things work a lot better. The same with my colleagues. Obviously, I visited when it was open. I was really impressed by the professionalism, the safety. You know, it was, yeah, a very good, you know, it's really good to see and get that insight, I think. And obviously, and the same as my colleagues saw an unlicensed premises, which was actually quite scary, to be honest. So, yeah, I fully support, yeah, the licensing. Thank you.
I guess I'm not going to be the only one not to say something. Yes, I think we must have due regard for comments by objectors. However, a lot of the objections were women feel unsafe in the town during race week. We have half of Ireland and perhaps a great number of the rest of the country coming into Cheltenham. An awful lot of alcohol is drunk in Cheltenham. This is not all the responsibility of Red Apple. So I think it is unfair to blame the safety or the feeling of unsafeness on one quite discrete business. The problem is the number of people and the amount of alcohol that's drunk throughout the whole of town that makes people feel. So I think we can discount that, albeit I do very much see that it is something that we need to take into our thoughts. The other side of it is, it's been said so many times, we have the exemption that operators could work under, which means that as a licensing committee, we have absolutely nothing that we could offer. If there was a real problem, it would be that the police would have to deal with it. It would be nothing to do with us as a committee. And personally, I think even if Max Wilkinson can get this exemption removed, I think we will still have a problem in that we will have illegal venues underground. So whatever happens with exemptions, I would still like that this council would have operators that would run the business with all the conditions that we can put to make it safe all round. And I think historically we have found that Red Apple have gone above and beyond to make sure this business is safe for performers, for employees, for customers, and for the general public. Not everyone feels that it is a palatable business, but that's not something we're considering today. We are considering the safety of the business, I guess, and for that reason, I'm happy to see this application granted again. So I think we need a. Do we have a? I can't see a. Just a, okay. That's it. Yeah. So if you could vote for or against, please. I think that's all of us. So that's unanimous in favour of granting the application. So thank you very much for your time. That in accordance with section 100A, paragraph 4, Local Government Act 1972, the public be excluded from the meeting for the remaining agenda items, as it is likely that in view of the nature of the business to be transacted, or the nature of the proceedings, if members of the public are present, there will be disclosed to them exempt information as defined in paragraph 1 and 2, parts 1, schedule 12A, Local Government Act 1972, namely paragraph 1, information relating to an individual, and paragraph 2, information which is likely to reveal the identity of an individual. Can we have a vote on that? I think a show of hands